Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Imagine buying a product, expecting the quality and trust of an iconic brand, only to discover it's a cleverly disguised imitation. We all rely on brand names. They're sort of shortcuts to trust, built over decades, sometimes centuries, right? Consistent quality, innovation. But what happens when that trust is deliberately undermined by these lookalikes or, well, outright counterfeits? Today, we're plunging into a really significant legal battle unfolding right out of the Delhi High Court. This deep dive focuses on a global automotive giant, Volvo, as they take on manufacturers and operators allegedly creating and using highly deceptive versions of their distinctive buses and branding. It's a fascinating look at the fight for brand identity in a market where, frankly, deception can have very real consequences.
That's exactly right. Our mission today is to unpack the intricate details of this pretty complex legal case. We'll follow the timeline, look at the key players involved, dissect the powerful arguments Volvo brought forward, and understand the court's initial, quite decisive ruling. Ultimately, we'll explore what this all means for brand protection, intellectual property rights, and maybe most importantly for consumer trust in this world of, complicated supply chains. The specific case we're digging into is Aktiebolaget Volvo and R v. Shri Ganesh Motor Body Repairs and Rs. That's CS KRM 6LMM 601D025.
Okay, let's set the stage. Laying out the fundamentals, the who and the what. So leading the charge, the plaintiffs are Aktiebolaget Volvo and its key associated companies like Volvo Trademark Holding AB, Volvo Car Corporation, and Volvo Trucks Corporation. And these aren't just any companies. They're, well, global titans in heavy commercial vehicles. Think the buses and trucks you see everywhere, and also premium cars. Their footprint in India isn't new either. Volvo India PVT Ltd was set up way back in 1996.
Right, a long time ago.
Yeah, and they rolled out their very first bus here in 2001, quickly becoming, synonymous with high-end, comfortable intercity travel. Okay, so on the other side, we have three key defendants in this legal drama. First, there's Ms. Shri Ganesh Motor Body Repairs, defendant number one. This is a sole proprietorship based in Udaipur, believed to be the main manufacturer of these alleged look-alike buses, led by a Mr. Kanhaiya Lal Lohar. Then we have two intercity bus operators, Ms. Rishri Bus Private Limited, defendant number two, and Ms. Shanti Travels, defendant number three. So you've got the big global brand, the alleged maker of the fakes, and the operators putting them out there for consumers.
Exactly. And this critical initial phase, this hearing, was before Honorable Mr. Justice Amit Bansal at the High Court of Delhi in New Delhi. That was May 30 in 2025. It's a commercial suit, which basically means it's in a specialized court designed to handle these kinds of business disputes faster. Volvo was seeking a permanent injunction against trademark infringement and passing off, plus an immediate request for urgent interim relief.
Okay, trademark infringement seems straightforward enough, using the mark without permission, but passing off. What exactly does that cover?
Right, so passing off is a bit broader. It's essentially about deceiving the public into thinking your goods or services are connected with or maybe endorsed by another well-known brand, even if you aren't using their exact logo. It's really about misrepresenting where your stuff comes from, trying to, ride on someone else's hard-earned reputation. That urgent request for interim relief really signals how seriously Volvo viewed the ongoing harm.
Yeah, that urgency makes complete sense when you think about the huge brand legacy Volvo is fighting to protect here. Can you maybe walk us through just how deeply ingrained this brand is, both globally and in India? It seems totally fundamental to their legal strategy.
Absolutely. The foundation of Volvo's argument really lies in its century of brand building. The trademark, the name VLVO itself, was adopted way back on May 11, 1915.
Wow, 1915.
Yeah, think about that, over 100 years of continuous global use. It's what lawyers call a coined and inherently distinctive trademark. It means it's not a regular word. Volvo created it. That gives them incredibly strong common law rights all over the world, building up this massive goodwill and reputation that's frankly, invaluable.
And their presence in India is just as strong, right? I mean, those buses became iconic pretty quickly.
Precisely. Their earliest Indian registration for the VLVO mark actually dates back to 1975. And critically, in 1998, the Trademarks Registry officially recognized VLVO as a well-known trademark in India. That came out of a really significant judgment. Aktiebolaget Volvo v. Volvo-lookalike Ltd.
Okay, well-known trademark. That sounds important, but what does being well-known actually unlock for a brand like Volvo? What's the real-world impact compared to just a regular trademark? Is it like a, I don't know, a legal superpower?
Well, yeah, you could almost say that. It's definitely a huge advantage. See, a regular trademark usually protects you for specific goods or services, like Volvo cars or Volvo buses. But well-known status means your brand is so famous, so tied to quality and trust in the public mind, that it gets protected across all industries. Someone can't just launch Volvo Pizza or Volvo software without infringing, even if Volvo themselves doesn't make those things.
Ah, I see.
It's a massive shield against diluting the brand's value, and it really helps consumers, ensuring that name always means Volvo no matter the product. It stops others from just, free riding on their goodwill.
So it's not just the word Volvo. They also have that visual element, that diagonal slash on the grille that everyone recognizes.
Indeed. Beyond the word, there's the distinctive grille/trademark, that iconic diagonal line on the front grille of Volvo cars, and crucially for this case, their buses. And that's not just a design flourish, it's a registered trademark in India, number 1930763 from 2010, that gives them exclusive rights to use it. Its placement instantly tells consumers, this is a Volvo. Plus, the overall look, the front-end styling, the whole aesthetic of their VLVO 9600 series buses, that's also protected as registered industrial designs under the Designs Act 2000. So yeah, we're talking comprehensive protection, name, logo, and the distinctive look and feel of the vehicles.
Okay, so with such a well-protected and recognized brand, how did this specific legal challenge even come about? What was the sequence of events that led Volvo to take this current action? Seems like someone was being pretty bold.
Well, it's almost like a detective story, actually. Volvo had dealt with something similar before. Back in 2019, they successfully sued a company called RS Yadav Smart Bus PVT Ltd. for using VLVO in its name and on its buses. They got a clear court decree, a win for Volvo. But then, maybe when they thought that was settled, something surprising popped up in 2022.
Oh.
During the enforcement process for that earlier judgment, trying to make sure RS Yadav was complying, they discovered they weren't just ignoring the ruling. They were allegedly operating buses with an infringing grille motif that looked identical to the Volvo grille slash mark, basically still running what looked like counterfeit Volvos.
Wow. So a previous win actually led them to uncover a new, maybe even bigger problem.
Exactly. That non-compliance kind of inadvertently led Volvo to the source of these lookalike buses. In March 2024, through RS Yadav, the plaintiffs learned about defendant number 1, Shri Ganesh Motor Body Repairs. That was the crucial link they needed.
And then came the smoking gun, so to speak.
Pretty much. In April 2025, Volvo's team investigated defendant number 1's owner, Mr. Kanhayal Lohar. And this is critical. Mr. Lohar apparently confirmed manufacturing these Volvo lookalike buses.
He admitted it.
Confirmed making them, installing those infringing grille slash motifs, and supplying them to RS Yadav's defendant number 2 and defendant number 3. And get this, on over 125 occasions.
Over 100 buses. Wow.
A huge admission. It gave Volvo direct evidence of, widespread manufacturing and distribution of these deceptive vehicles. That admission then prompted further investigation into the operators, defendants 2 and 3, between May 20th and 27th, 2025. And that all culminated in Volvo filing this lawsuit and getting that immediate interim injunction on May 30th. Looking ahead, the case continues. The next dates are August 7th, 2025, before the joint registrar, and then October 9th, 2025, back before the court itself.
Okay, that's a really clear timeline of discovery and action. Now let's turn to the courtroom arguments. What were the core points Volvo presented to the High Court to make their case for protecting this global brand?
Well, Volvo's arguments were sort of layered, but they all built on the sheer strength of their established rights. First, they hammered home the power of the VLVO trademark itself, a coined term, used for over a century, registered everywhere, India since '75. They lean heavily on that well-known status, which, as we discussed, gives it that super broad protection across different goods and services. And, of course, the uniqueness and their exclusive rights to that specific grille slash mark were a major focus.
Right, and then they had to show the defendants were actively, misleading people. How did they build the case for that deceptive conduct?
They laid out specific examples. For defendant number 1, Shri Ganesh Motor Body Repairs, the accusation was manufacturing nearly identical and deceptively similar buses with those infringing grille motifs. And, like we just heard, admitting to supplying them to the other defendants and RS Yadav. For defendant number 2, Mrs. Rishabh Bus Private Limited, the claims were pretty damaging. They were accused of buying these lookalikes and then actively misleading customers by advertising their fleet as Volvo buses on major travel sites Make My Trip, Afibas, Paytm, even though they didn't actually have genuine Volvos.
So it's not just about looking similar, it's about actively selling a lie to customers who are paying for something specific. That affects real people, doesn't it?
Absolutely, and Volvo highlighted that. They even cited a specific customer review from someone named Sathian on Just Dial. Sathian explicitly said they paid for a multi-axle Volvo, a premium service, but got an ordinary bus.
Oh.
They felt totally cheated. Exactly. It vividly shows the direct consumer harm. People pay extra, expecting that Volvo experience, that quality and comfort, and they get something completely different. It just erodes trust completely.
And what about defendant number 3, Mrs. Shanti Travels? Was it a similar situation there?
With defendant number 3, they were accused of operating buses they got from defendant number 1 using a grille motif that was nearly identical to Volvo's, but they put Shanti on it instead of VLVO.
Okay, so a slight difference, but still visually very close.
Right. While not using the VLVO name on the grille, the argument was that the overall visual similarity of the bus design and that distinctive grille shape was still deceptively close, leveraging the whole Volvo aesthetic to confuse customers. So overall, Volvo basically characterized all these actions as a mala fide attempt, meaning done in bad faith, to encash on the plaintiff's rights. They called it clear infringement and passing off, a deliberate effort to ride piggyback on the plaintiff's immense reputation and goodwill.
And finally, Volvo argued there was a threat of irreparable harm if the court didn't step in quickly. What did that mean for their brand? What was the specific danger?
They argued that if this infringing use wasn't stopped immediately, the whole practice would just become rampant. It would spread. And the exclusivity associated with the plaintiff's buses and the grille slash mark would vanish over time. Critically, they emphasized that any problems, safety issues, breakdowns, poor service with these look-alike buses would inevitably reflect badly on Volvo because consumers would be confused. It would directly damage Volvo's carefully built goodwill. So all of this, they argued, established a prima facie case, meaning on first look, there's strong evidence of infringement, and that meant the balance of convenience squarely rests in favor of restraining the defendants, justifying that immediate court intervention.
So, given those arguments and the evidence, particularly that admission, what did the court decide in this initial phase, especially with the defendants not even showing up?
Well, that procedural point was absolutely key. The fact that none appears on behalf of the defendants despite advance service, meaning they are properly notified but chose not to attend, allowed the court to proceed ex parte. That just means deciding based on one side's arguments for now.
And the result of that ex parte hearing?
The court granted an ex parte ad interim injunction. This is a temporary but immediate order. It's granted quickly, without the other side's input at that moment, specifically to preserve the status quo and stop immediate ongoing harm. The specific restraints were broad and hit immediately. Defendants 1, 2, and 3 were instantly stopped from using, manufacturing, marketing, selling, displaying, advertising basically anything involving buses or services bearing the VLVO mark, that distinctive grille slash mark, or any confusingly similar marks or front-end designs. A complete halt to the alleged infringing activities.
It sounds like the court was really convinced by Volvo's initial presentation, even without hearing from the defendants yet. What was the explicit reasoning given?
Yeah, the reasoning was pretty strong. The court stated it found clear evidence that the defendants were violating the statutory and common law rights of Volvo. The judge explicitly said the defendants had deliberately and dishonestly copied and created fake-replica look-alike counterfeit products. That wording, deliberately, dishonestly, is quite powerful. It suggests the court didn't see this as accidental similarity at all.
Right, they saw intent.
Exactly. They agreed with Volvo that letting this continue would make the practice rampant, and the exclusivity associated with the plaintiff's buses and the grille slash mark will vanish over time, which directly threatened Volvo's goodwill. That strong finding of deliberate copying, combined with the clear threat to the brand, is why the court determined the balance of convenience squarely rests in favor of restraining the defendants. Hence, that immediate powerful injunction.
Okay, so the court's decision clearly rested on a solid legal framework. Could you maybe just briefly touch on the specific laws and codes that were actually cited here?
Sure. Several key pieces of legislation were involved. The Commercial Courts Act 2015 was important because it allows for procedures like filing additional documents quickly, which helps speed up these kinds of business disputes. Then there's the Foundational Code of Civil Procedure, 1908, the CPC. That governs how lawsuits run things like filing documents, requests for information, interrogatories, and of course the injunction itself, under Order X-9 Rules 1 and 2. The court also had to follow Order X-9 Rule 3, which requires informing the defendants about an ex parte order like this one. And interestingly, Volvo used Order 2 Rule 2 to reserve their right to bring future claims, maybe specifically about design infringement, showing they might pursue that angle separately later.
And newer laws came into play too, right? Something about evidence.
Yes. The new Karthya Sakshathiniyam 2023, which deals with evidence, was mentioned regarding a certificate for electronic evidence under its section 63(4)(c). And while this immediate suit focused on trademarks and passing off, the court did acknowledge that Volvo's Volvo 9600 bus designs are protected under the Designs Act 2000. Volvo specifically kept the door open to file separate design infringement proceedings if necessary. It really shows the layered strategy big brands use.
Okay, statutes are one thing, but courts always look at previous judgments, precedents. What specific case law was important here?
Absolutely, precedents are key. One major one was a Supreme Court judgment, Yamini Manohar v. T.K.D. Krithi from 2023. That case was cited as the reason the court could grant an exemption from pre-institution mediation.
Skipping a step. Why is that significant?
It's a big procedural shortcut. Usually commercial cases have to try mediation first, but Yamini Manohar allows skipping that. If you need urgent interim relief, like Volvo did here, it lets you get before a judge much faster when there's immediate harm happening.
Got it. And the case that established Volvo's well-known status, that must have been crucial too.
Definitely. That was the Aktiebolaget Volvo v. Volvo Steel Ltd. judgment from the Bombay High Court back in 1998. That's the very case that officially recognized Volvo as a well-known trademark in India. As we discussed, that status gives it the absolute strongest protection across all types of goods and services, making it incredibly powerful in any later trademark case like this one. The court also noted Volvo's previous successful suit against R.S. Yadav, the 2019 win and the 2022 enforcement efforts, seeing it as evidence of consistent judicial protection for the VLVO mark. That history probably made the court more confident in granting immediate relief this time too.
So this ex parte ad interim order gives Volvo immediate breathing room. But what's its broader significance? Does it set some kind of major new precedent in trademark law?
Well, it's important to be clear here. Because it's an ex parte ad interim order, meaning temporary, and decided without hearing the defendants, yet it doesn't set a binding substantive precedent on trademark law itself, or the final decision on whether infringement actually happened. It's provisional. The defendants will get their chance to argue their case, present evidence, and the order could potentially be changed or even canceled later on. So it's definitely not the final word on the court issue.
But it does signal something important about the court's stance, doesn't it?
Well, absolutely. What it does reinforce are things like procedural precedents, the court's willingness to skip mediation for urgent cases, for example. And it strongly signals the court's proactive stance on protecting well-known marks, especially when there's clear initial evidence of infringement and the defendants don't show up. It sends a powerful message to potential infringers. Indian courts are ready and willing to act fast to protect established brand rights. And since it was a single judge, Justice Amit Bansal, it was just one clear, decisive ruling at this stage. So in the immediate term, yes, this injunction is critical relief for Volvo. It puts an immediate stop to the alleged infringement, protecting their brand's exclusivity and reputation from potentially getting damaged further while the full legal process plays out.
But let's zoom out for a second. Why does a case like this actually matter to you listening right now, even if you never book a bus ticket? This deep dive really shows how the legal system works to protect brand identity and reputation, things we rely on, in a world where, let's face it, supply chains are complex and copying stuff is easier than ever. It highlights the real muscle behind that well-known trademark status. It's not just for the company. It helps ensure you actually know what you're buying, whether it's a luxury car or, a bus ticket. And maybe most importantly, it really underlines why being an informed consumer matters. This case, especially that customer story, reminds us how brand deception isn't abstract. It can directly impact your experience, your money, your trust. Protecting brands isn't just about corporate stuff, it's about protecting the trust you place in the products and services you choose every single day.
And that really brings up a crucial question for all of us, I think. In this increasingly globalized digital world, How do we strike the right balance? How do we foster innovation and fair competition, but also ensure robust protection for established brands and, critically, prevent consumers from being deceived? What more can be done? Not just by courts and brands, but maybe by online platforms, maybe by us as consumers, to make sure that a lookalike doesn't just chip away at the trust built over, in this case, a century. How do we empower everyone to truly know what they're paying for? It's a constant challenge, really, in the modern marketplace.